How's it going, everybody? In this video, I have an update for you on the Duncan v. Bonta California magazine ban case and some new things that have been filed. So let's talk about this. But real quick, before we jump into this video, if you think the state of California's ban on so-called large capacity magazines violates our Second Amendment rights, go ahead and hit that like button and subscribe. I also want to give a shout out to one of the main supporters of the channel, which is USCCA. Through your membership, you get training, education, and self-defense liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I'll put a link to them down in the details section. I also want to let you know that this content is powered by the Firearms Policy Coalition. So head on over to joinfpc.org to help support the Second Amendment cause. Thank you again, Firearms Policy Coalition, for supporting this channel. So like I said in the intro, in this video, I have an update for you in the California magazine ban case, also known as Duncan v. Bonta. The plaintiffs in this case have filed a motion to stay the mandate of the en banc panel in the Ninth Circuit until the Supreme Court can address this issue, or in the alternative, they are seeking an administrative stay until they can seek a stay actually from the Supreme Court. So let's talk about what's going on. Also, I want to mention real quick that although I am a licensed and practicing attorney in the state of California, I am not your attorney. This is not legal advice. I am not providing you legal advice as your attorney. This is just some general information so everyone understands what's currently going on with this Duncan v. Bonta case. Now, Duncan v. Bonta, previously known as Duncan v. Becerra, involves the possession of so-called larger capacity magazines in the state of California. California Penal Code Section 32310 bans the buying, selling, possession, etc. of magazines that hold more than 10 rounds that most ordinary citizens in other states could actually possess, but not in the state of California. This law was challenged in the Southern District of California before Roger T. Benitez, or Saint Benitez, and he issued a ruling finding that this law in the state of California violated our Second Amendment rights. This led to what is called and known as Freedom Week in California. During that week period of time, tens of millions of magazines were purchased by California gun owners. Now, after that week period, the ruling by Benitez said that those in lawful possession of Freedom Week magazines could maintain them essentially without fear of prosecution from the California Department of Justice or other law enforcement. The enforcement of the law against the possession of magazines, these pre-ban magazines, as well as these Freedom Week magazines, was essentially enjoined by Judge Benitez. Well, the state of California, after this ruling, didn't like that, so they decided to appeal up to the Ninth Circuit. A three-judge panel in the Ninth Circuit reviewed the decision of Judge Benitez and agreed with him. Well, after California lost again, they sought a rehearing en banc, which means a review by 11 judges in the Ninth Circuit. The en banc panel heard the case and issued their ruling, finding that California's magazine ban does not violate Second Amendment rights. The en banc panel therefore reversed the decision of Judge Benitez and is remanding the case back down to him, but only to enter judgment in favor of the state of California. Now, as of right now, it is still legal for you to possess pre-ban magazines and Freedom Week magazines, only because the Ninth Circuit has not issued a mandate back down to Judge Benitez for him to rule. Once a mandate is issued by the Ninth Circuit, then Benitez will have to remove the injunction that he put in place, which has led to the lawful possession of these Freedom Week magazines and these pre-ban magazines as well. Now, one solution to try to prevent the mandate from happening from the Ninth Circuit is to seek a stay of mandate pending a petition for certiorari in the Supreme Court. And that is what the plaintiffs did yesterday by filing their motion for a stay of mandate and, in the alternative, an administrative stay. The goal of the stay is to maintain the status quo of how things currently are until the Supreme Court could actually address this issue. Now, to get a stay of mandate, the motion must be served on all parties and must show that the petition to the Supreme Court would present a substantial question and that there is good cause for a stay. In their motion for the stay, the plaintiffs argued there is substantial questions here because of the 15 judges that have heard this case, have heard about this ban in California, 7 have agreed that it's unconstitutional. On top of that, they point to the fact that the Supreme Court has recently held the A&J RPC case, which is seeking review from them, the Supreme Court, and that deals with the New Jersey ban on magazines, which is very similar to the California ban on magazines. Because of these, they say there is a substantial question, and therefore, on that basis, there should be a stay of their mandate. They also argue there's good cause to stay the mandate because if a retrospective and confiscatory possession ban is allowed at this point, it would result in irreparable injury. And that is because if the magazines are given up now, there is risk that the Supreme Court will later hear this issue and find that what the state of California has done is unconstitutional. But at that point, the Ninth Circuit, if they don't stay their mandate, would have already required that everybody give up their magazines. In this section, the plaintiffs state that unless this court withholds the mandate, those law-abiding citizens will immediately become criminals unless they hand over their lawfully acquired property for destruction or otherwise dispossess themselves of it. There is no reason to disrupt the status quo and turn law-abiding citizens into criminals overnight before the Supreme Court can even consider the substantial questions that plaintiffs' forthcoming petition will present. Now, that is the stay that they are seeking from the Ninth Circuit. In the alternative, if the Ninth finds that there is no substantial question and no good cause, they are seeking that the Ninth Circuit issue an administrative stay on the mandate. What this means is that if the Ninth Circuit doesn't want to issue a stay, they should hold off on the mandate at least until the plaintiffs can go to the Supreme Court and request a stay from the Supreme Court. So the administrative stay is essentially a partial placeholder until they could ask the Supreme Court for a stay. One thing I also want to note is that with a stay from the Supreme Court, that is not a guarantee. Currently, Justice Kagan oversees motions like this from the Ninth Circuit. So motions like this coming out of the Ninth Circuit are within her control and review, and she gets to decide on what she would do with this. That might not bode well for us, but maybe in this scenario with the A&J RPC case being on hold and the Bruin case being recently heard by the Supreme Court, maybe that would sway her if it got to her to issue the stay. Now, for the stay that is being sought from the Ninth Circuit, also, they don't have to issue that stay. But that motion that was filed went unopposed by both parties, and that bodes well for the Ninth Circuit actually issuing that stay. An unopposed motion essentially means that the state of California has agreed they have no issue with the Ninth Circuit holding this issue until it's heard by the Supreme Court. So we will see how this kind of plays out, but I would expect the Ninth Circuit will issue the stay of mandate, especially since it went unopposed. But when we get a notice of what they actually do, I will definitely let you guys know. And for those of you who are still watching and maybe you're still confused after all of this, as of right now, nothing has changed as far as you still being able to legally possess pre-banned magazines and Freedom Week magazines. And the only thing that will necessarily change that, and the one thing we're really keeping our eyes on, is if the Ninth Circuit will issue their mandate. But right here with this motion, the plaintiffs are seeking to actually stop that mandate. So if you guys have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and it signals to YouTube and everybody else who hates that joke that you value these videos, you value this channel and this type of information, and it pushes it to more people. So thank you so much to everybody who's liked, commented, subscribed, just hit the notification bell. You guys are directly impacting these videos, impacting this channel, and helping it reach more people than I could have ever thought, and helping to educate more people than I could have ever thought. So thank you so much for all of your support. If you don't have a comment in mind, just comment down below that you're commenting to fuel the algorithm, and I really do appreciate that. So as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.